Justice
short
S.B.
list of dates.
Majmudar, who was Lord Chief Justice of your Lordship's court.
Yes, yes, court here also.
Next page, Your Lordship, may kindly see. The 2 days, 27/9, both sequence of events with regard to pursuant to your Lordship's order and local complaint being given.
Yes, sir. Dave, sir, continues.
Yes, my lord. Kindly turn to page 35, my lord.
Page?
41. Relinquishment, it is at 41. What if,
Yes.
Aditya, what I am referring to is para 1.
Correct, sir. You read 41.
41, my lord.
Yes.
41. Lord, please turn to 41. It's in English?
One other aspect, my lord.
Yes, my lord.
Complaint was filed at 11:59 in the morning. It's an writ petition. Immediately after filing the FIR. The timing is also very important.
How did you get that?
It's in the website itself,
All right.
High Court website.
We'll see. Yes.
11:59 in the morning.
My lord, technology has its own advantages and disadvantages.
ಏನು ರಾಹು ಕಾಲ ನೋಡ್ತಾ ಇದ್ರ
ಅಲ್ಲ, ಅವ್ರು ಹಾಕಿರೋದು, ನಾವು ಹಾಕಿರೋದು.
Now see page 41, my lords. Before the revenue inspector, Mysore Taluk, residents of house number so-and-so, Sri late Ninga Jivara, first son of Malaya, late Malaya, his wife so-and-so, and their son so-and-so, Mysore Taluk, land survey number so-and-so, so-and-so, transfer application form 19 filed by late Ninga Jivara, son Devaraju. That's my client. Said land belongs to Ningra Jivara. Currently, it has expired. Said land is not portion amongst them. Already we have sold 4 acres, belongs to our family. We don't have any objection to transfer of Katha of the said land to Devaraju. Written as stated in oral statement. We have read and listened and given statement. It's correct, agreed and signed. But this is a vital document which has been withheld. I am sorry to say that your lordships have been taken for a ride. No, my lord, it pains me. Because if this was not told to your lordships would not have recorded a finding against me that I had no right, title and interest, and yet I proceeded to sell the land. My lord, this was a family settlement. My lords are aware, Kale's judgment of the Supreme Court, Justice Krishna brilliantly speaking, why court should adhere to family settlements. My lord, there were debts incurred by the family. I came forward and said, I will discharge those debts. The lands were mortgaged. My one surviving brother and another brother's widow and son both agreed. And that's how it came to be transferred to me. Now, this document is available on record. We have got it from record. Petitioner could have got it from record. I have no doubt he saw it. But my lord, keeps it away from your lordships. Now turn to my lord. 42 is the mutation, my lord, of that order, mutation order. Again suppressed.
Oh, these are of 92, 93 itself.
Yes, my lords.
All right.
Now, please kindly come, my lord, to paragraph where I had stopped, my lord. Para 1 at page 3 now. Roman 2. Further, the revenue authorities, page 3, Roman 2. Further, the revenue authorities, by accepting the said arrangement, effected mutation of revenue records, vide so-and-so, wherein the no objection of family members of answering respondent for bringing his name into record is specifically noticed. True copy of mutation record is produced herewith, marked as annexure 12.2. Pursuant thereto, register of tenancy and crops is RTC is also drawn up. They reflect the name of answering respondent from 90 to 93 onwards. Two true copies of RTC from 92 to 97, 98 are produced herewith.
Yes.
Then next page. Therefore, it is crystal clear that answering respondent had validly secured title to and was lawful owner. Now, my lord, on denotification, what they suppress? Next para. Even in relation to denotification of the subject land from acquisition proceedings which were commenced in 92, true facts were not placed. This honorable court was not made aware that procedure for denotification was commenced by authorities on 24th July 1997.
One moment. Now, the investigation they have done, records are with me. I will see the records and see whether it is necessary to be referred to the CBI or not. Because these, if I get into the facts again, then it would be sitting in appeal over what I have already written, which is.
No,
pending
my
before
lord.
Supreme
Your
Appeal, that's all.
lordship says not, I was not a party. In my
No, that's-
absence,
yes.
whatever has been said is not binding either on the court or on
That's
me.
all right. I will record all those submissions.
Yes,
It's not because I can't, as you are well aware, I can't rehear the matter. That's the
No,
only.
no.
Because
Your lordships can
in the
certainly
teeth of-
say, your lordships can certainly say and must say that these facts were not brought to my notice.
All right, you submit, no problem.
That not your lordships.
If I may say so, this court is a court of record.
Ah,
We are
anything that
going
is
to
on record.
we are going to place our material because we were
Yes.
not heard. We were not parties.
All right.
How the court has been taken for a ride,
Allah.
how
Yeah,
information is suppressed, all that will place it. Court will have to exercise under Article 215 its right to correct the injustice, correct the errors that have already kept on record.
we'll see. Yes, sir.
My lord, I will add to that. Your
Only
lordships are,
only
just a
one
second.
submission.
Don't interrupt, please. Don't
No,
I
Mr.
request you not to interrupt.
Dave, sir.
I am not interrupting. I'm just communicating to the court.
Communicate at your turn.
Okay. You please proceed.
Yes, Dave, sir, you carry on. Yes.
My lord, because it kills my thought process. I'm sorry to
you,
say.
you,
You're
you
my
carry on
senior.
with your flow. Yes.
Yes, my thought process. My lord, it's not, your lordships are not just a court of law. Your lordships are a court of equity. And equity does not aid somebody who comes with unclean hands. That's a very simple proposition your lordships have always accepted. For Lord, in England for almost 200 years, our own courts for last 100 years, Lord, 150 years, Privy Council down to Lord, your lordship's court. So, my lord, that's something which your lordships would be very, very, my lord, serious about. That you, my lord, parties' rights. My lord, this is not just about my civil rights. This is about my Article 21, my liberty. My liberty is sought to be, my lord, seriously impaired because of, my lord, getting these observations from your lordship's court by suppressing vital facts. My lord, it is seriously going to hurt me. I am in appeal. Your lordships are right. But, my lord, since your lordships are, my lord, being asked to post haste decide this case, I am respectfully, my lord, beseeching your lordships with folded hands that please kindly consider my position. If I am innocent, then, my lord, I should not even be party in this criminal complaint. Any, my lord, transfer to CBI will hurt me. Further, the judgment has already hurt me. The complaint is already hurting me. I have nothing, my lord. That's why, my lord, I am making.
All right, sir.
I'm at pains to persuade your lordship
Yes.
that this case. Now, just see this plot, para 4, page 4, para 5. Even in relation to denotification of subject land from acquisition proceedings which were commenced in 1992, the true facts were not placed before this honorable court. This honorable court was not made aware that procedure for denotification was commenced by authorities on 24th July prior to final notification of 20th August 1997. But most important aspect, the denotification started not after acquisition, before. And our land was not acquired, which was withheld from your lordship's court. See further. Further denotification of land occurred on 18/5/1998 prior to issuance of personal award notice on 15 February 99. I am at page 4 and 5 of my reply.
Yes, sir.
Kindly see that, page 4 and
Yes.
5. Page 4, bottom.
Yes.
Para Roman 6. This
Yes.
honorable court was not made aware of the fact that procedure for denotification was commenced by authorities on 21st July prior to final notification of 20th August. Then para 7. Furthermore, denotification of land occurred on 18th May 98 prior to issuance of personal award notice of 15th of February. More importantly, Honorable Reference Court before which compensation was deposited by Muda on 15th March returned the same on 3rd September. Holding that procedure adopted by Muda for deposit award amount was not as per law. Now, my lord, all this is not told to your lordships. Your lordships are simply persuaded to say that, oh, acquisition was complete and therefore how could denotification have taken place? My lord, your lordships are aware. My lord, I am not on merits or demerits of denotification. Those are matters, my lord, of your lordships, my lord, judicial notice. But large-scale denotifications do take place. Lord, I am a small farmer who went to Lord, the authorities, begged them that this is my land, please allow a denotification. It had nothing to do with chief minister or deputy chief minister. I didn't know that I was going to sell him later and that his wife 20 years later is going to get some several small pattas or whatever it is. All this is figment of imagination. It's like Thomas Hardy's novel, sheer coincidences. So, my Lord, I respectfully submit that I am being condemned for nothing. My Lord, can it be said that there was a criminal bent of mind? My Lord, mens rea must exist. When, my Lord, these transactions took place, there was no mens rea then. Land was not released. Somebody came forward and brother-in-law and said, I don't know who is he. He is from my district. I sold it to him for a paltry consideration. How am I to be damned today? What is the corruption charge against me? Whom have I bribed? Whom have I bribed? I am neither the bribe giver nor the bribe taker. And yet I face, Lord, whom have I cheated? A public interest litigant. But cheating must be complaint must be by a person who's cheated.
There should be an aggrieved person.
Exactly, my Lord. A PIL petitioner can't say that I'm cheated and therefore order a 420, 416, all these investigations. Then, my Lord, Roman 9. Roman 9. Most importantly, notification under section 16(2) of the Land Acquisition Act, which shows that possession of land in question was not taken, is also approved sanctioned layout plan, which shows that land as denotified area were not brought to the notice of this honorable court. Copy of the notification under 16(2) is produced herewith. So, my Lord, all these, my Lord, were, and therefore, my Lord, just see now the findings that your lordships recorded in next page.
Now, Dave sir, till here, definitely I will listen, no problem. Now
Yes.
we are speaking about my judgment, hearing that will not be correct because it is in appeal. I will consider all your submissions made in para 1 and answer them.
My Lord, if
But
it is your
If it
lordships
is,
are right.
no, if it is against, if you're now speaking about my judgment, then it may not be correct for me to do that.
Then, my Lord, it may not be correct for your
I will consider all that, no problem.
Lord, I am grateful to your lordships. But then
Yes.
it may not be correct for your lordships to hear this matter pending the appeal.
No, that's not.
No, my Lord, your lordships
That's
can't have it both ways.
All
Either
right.
your lordships allow me to attack your judgment before your lordships, or wait for, my Lord, the appeal court decision. It's not
All
fair, my Lord, for that your lordships say that you will
All
not go into it. I want
All
to
right.
tell your lordships that these
All right.
findings
You-
could
you
not have
submit,
been
sir.
arrived at because
You
of
s-
suppression. I am
You-
making
No
allegation
problem,
against
sir.
the
You
petitioner.
submit, you submit.
Lord,
Yes.
I am making allegation with all responsibilities against the petitioner who
Yes.
has not been fair with the court. If these facts were within your knowledge, your lordships would never have recorded this finding. I have no doubt. I have no doubt about it. And your lordships were entitled to rely upon a public interest litigant because your lordships always will trust the petitioner who comes before the court. But, my Lord, that trust was belied. He has committed breach of that trust. So, my Lord, now see para 45, what your lordship said. Devaraju submits a representation contending that he is dependent on land and has no other income, and therefore the land be dropped from acquisition.
Oh, it is
Sir, recommend-
concerning Devraju, is it?
Yes, my Lord.
That's all. Then you can submit.
That's all. I'm not on others.
Yes,
Lord,
yes.
your lordship, if others are to be damned, I have no concern about it, my Lord. I am concerned about my poor client. He should not be, my Lord, he become a victim because of this slugfest between this public spirited kind journalist, film
And-
director, film producer, and my Lord Chief Minister. I am not concerned about that, my Lord. I am concerned about my. I think that, my Lord, there is a serious, I would say, and your lordship knows one thing, that if a judgment has been obtained by fraud, it can be set at not at any stage. That's a settled law, my Lord.
No, that is for me to answer. We'll do it.
Yes. No, I'm just saying that's settled law.
Yes, yes.
That is settled
No,
law.
that fraud unravels everything. Is a
Exactly, my
settled-
Lord. That's my respectful submission.
Yes.
Yes. In fact, your lordship knows that such a judgment is a nullity as has been held by courts time and again.
All that you need not rely on it.
Yes.
It's too rudimentary.
Yes, yes. And no, and certainly not before your lordships, because your lordships are fully aware of all the law. Lord, that I Lord bow down to that. It's always a joy to appear before a judge who knows law so well, my Lord. So our task is reduced substantially. Now kindly turn to this finding in para 45 at page 6.
Yes.
Devaraju submits a representation containing he is dependent on land and has no other income and therefore land be dropped. Muda recommends for dropping of the land and government issues notification accordingly. Devaraju at that time when he submits the representation is said to be working as a teacher in Department of Public. Therefore, it was on a false pretext that Devaraju sought denotification of land and said land is deload. Now, this in my respectful submission is not a correct finding. If your lordships were told all facts and given all the documents, your lordships would not have said this. Denotification itself is contrary to law, as the land is denotified after deposit of the award. No, but it was not even award notice came subsequently on 15th February 99, much after denotification, and the amount deposited was returned by civil court. Not by me, not by revenue authority who are under control of these politicians. Civil court felt that this is not in accordance with law, take it away. So all these, notwithstanding this, the land is denotified owing to falsehood of Devaraju. Devaraju could not have claimed the land being son of original owner as he has already relinquished his rights. Lord, I will go to jail with these findings. I will have nothing to argue. I stand condemned, Lord, beyond repair. After all, which Lokayukt court will not go against your lordship's findings? As he has already relinquished his right in favor of his brother Mallarappa, Mallarappa does not apply for denotification. It is Devaraju who applies. Nonetheless, land is denotified. What's the time? Muda, then page 7. Muda did not act on this request for denotification but went on with acquisition process. After the final denotification was over, it transfers Muda on 30th August 97 drew up some proceeding with regard to dropping of subject land from acquisition. All this is incorrect.